So, without further ado, it's my pleasure to introduce Jonathan Price, who is a PhD a fellow and lecturer at Leiden as well as Oxford, and who is writing his thesis currently on history of the category of the person in law. So, please give a warm welcome.
As you can see from my picture in the program, the hair transplant surgery was successful, and it only cost all of the hair on my left thigh. The photo, unfortunately, comes from my official Leiden Law webpage, which, due to the bureaucracy of the modern university, is nearly impossible to change once it's established, so I'm just going to have to go with it. I want to thank Blackfriars, where I'm a member and associated and do a bit of teaching, and was once a student, and the University of Warsaw, a town which, as of next week, will be a place of residence for me for a while, as my wife and son are Polish, and also the Ian Ramsey Center for sponsoring this, and hopefully, if it all goes to plan, we can get them to do it again. I want to first just throw 4 categories of legal persons, or 4 instances of legal persons out, and I'm going to tell you what I plan to say, and, well, as you can see, I'm dressed more like a lawyer than a philosopher, so what you're going to get is a bit of history, a bit of philosophy, and a suggestion for what's happened to person as it's made its way from the theater through Roman law, through its Boethian and Thomistic days, and up into its post-Hobbesian existence. So, I want to mention 4 things that are variously considered persons in different legal systems. One is a corporation, quite commonly. Another is Bart Simpson. This is a clipping from a train newspaper, Metro, on the train between Leiden and Amsterdam. And what it actually says is, in translation, sex with Bart is kinderporno, so child pornography. And some of you might know the case in Australia where the judge ruled that fictitious persons are also persons. So if you depict sexual relations between fictitious persons who are also of age of minority, who are minors, then that could also be considered child pornography. So see how this extends. Another category is great apes, which I believe in Spain have some sort of qualified personhood under the law, since I think this is since Zapatero and the kind of turn toward progress as understood in Spain. And the last is the unborn, who are variously considered persons or not persons, depending where you are in legal systems. These are 4 things, or inventions, fictive things, that variously fall under the category of person in the law. And the question is, well, what do we mean when we say they're persons under the law? Of course, that kind of begs the question a bit. We need to know what we mean by person, or what has been meant by person. But they should be kept in mind as examples that could be appealed to throughout what I say, or in the question time later. Okay. I'm going to set up the discussion. I'm going to introduce 2 legal persons, 2 categories of things that when jurists or legal philosophers or sometimes lawyers talk about persons, they're speaking about these things. I'm going to give a brief history of the term person and a few working concepts behind it, including some relevant turning points in its development, relevant for what I want to say about human beings as persons in law. And finally, I want to suggest some possible consequences of persons' modern development. And I'm using modern here as post-Hobbesian. And that'll be, when I say modern, I'm talking about after Hobbes, things that happened philosophically after him. Okay. Let me read my abstract out and then tell you what's true about it, or what I'm actually going to cover. So it seems that not so long ago something happened to the concept person, as a result of which it has become difficult for it to connote what was legally and historically one of its most common senses, a corporate person, for instance that of Hobbes' Leviathan. I shall trace some of the movements of the concept of person from its Greek theatrical beginnings, its Roman law days, its theological developments in Boethius and Thomas Aquinas. Grotius is not there. Hobbes' dealings with it, and up to the present day. The sketch will identify certain ideas and concepts that have been rolled into what we now mean by person, as well as where they have come from. That's kind of redacted up to the precipice of truth. And what I'm actually going to discuss is how, whereas the concept of person once defined the essence of what we meant by human being, now it seems that what we mean by human being is defining person. And that law is giving some indication of this movement. So the concept was defining the human being, now the human being defining the person. So I'll get to that. Okay, a common statement that gets us down this path is this half statement and half question. It starts with, not every person is a human being, but is every human being a person? And anyone who's dealt with this philosophically has probably asked a question somewhat like this and proceeded to answer it. The first half of the question, not every person is a human being, seems to need more defense than ever, at least on the flanks that include corporations and other non-corporeal entities as persons. I suggest that three things have made it difficult for person easily to connote a corporate or artificial person, both culturally but also philosophically and maybe even legally. Three things. One is that person has come nearly to mean human being in the primary signification of person. Two is that person seems to mean individual, and I'll define individual philosophically later, individual and especially corporeal individual. Three is that person implies volitional activity in such an individual. And that is, persons are beings who desire and choose, have wills that are in some way free. Okay. So then the questions then are, can non-human beings be persons? Again. And secondly, can non-corporeal beings be persons? For the Romans, Boethius, Thomas Aquinas, the answer to both was yes. I think we are leaning toward the answer being yes to the first, so can non-human beings be persons, and no to the second, can non-corporeal beings be persons? And I'll explain why. So, the notion of human being, or man, understood as a corporeal individual with certain faculties, seems to have become the standard of person, and also what person most often denotes, supplanting older concepts of person not based solely on human being. For example, God as the ideal of a person that you get in Thomas Aquinas, derived from Boethius' definition. That is, humans are persons insofar as they meet the definition of person as an individual substance of a rational nature, but they aren't the only persons. The shift may also be happening or mirrored in law. One of the most relevant parts of law of persons is its ability to recognize and support actors that are not natural persons. This is historically one of the most striking things, but are set up for the benefit of the commonwealth, or that protect individual natural persons from personal liability or full personal liability. Corporate persons and trusts play this role variously in different legal systems, and they tend to encourage risky behavior that should have a public benefit, investments, for example, with limited liability, by shielding the natural person from the legal person, or by shielding whatever is behind the legal person from full liability. Moreover, in law and everyday life, there have always been, or we've always thought that there's been, non-human persons, which may include the three persons of one substance of the Trinity. We've already said corporations, fictional persons, such as the Cheshire Cat in Alice in Wonderland, and that has a social reality to it, but also then Bart Simpson in legal fictitious personhood. And in Spain, great apes, so bonobos, chimpanzees, gorillas, and orangutans, which have some sort of personhood. The divine, legal, and fictional personhoods have become harder for us to believe truly to be persons, as personhood has become more synonymous with man. And what you see here is a curious thing has happened. Great apes have benefited from this move. Great apes have benefited from this move, perhaps because they're individual corporeal beings that might have volition. That would be the suggestion of why it seems more natural to us to start looking toward them to apply personhood, rather than to look toward a corporation or toward a fictitious person or toward God or something of that sort. Okay. That was just trying to set up the problem and suggest a little bit of where I want to go with it. I want to talk about the two persons of law quickly, and that is the person of law versus person in law. The person of law is kind of an answer to the question, for whom is law? To whom is it oriented? And who does it presuppose? It is not made for corgis or minerals or tin cans, but persons. And curiously, it's not even made for human beings as a biological thing. It's made for persons that it assumes can interact with it in a certain way. It is the way in which law conceives of its addressee. The topic, if you want to look more into this, is variously called. It doesn't have one name. It's variously called legal personality, legal personhood, legal identity, or sometimes even legal status. So this whole area of for whom is law is variously called, one more time for those writing, legal personality, legal personhood, legal identity, and sometimes legal status. Discovering who this assumed person is terribly interesting, as it betrays the prejudices and assumptions of the age in which law is written and their thoughts about persons. I'm not going to do that here, but you should know that that's one way of speaking about the person of law. Person in law, or within law, is what I'm going to speak about. And there's two kinds. Those recognized in law, but natural. So, prior to law, have some existence outside of law. Second is those recognized by law, but artificial. Of the second category, there are two subcategories, and that is those created by the law, and those created by some other means, and then recognized by the law. So they're artificial, but not legally artificial. So you might have a private society that's then later recognized in the law as a non-profit corporation or something of that sort. So it's known to be a pre-legal entity that's then recognized, but it's not a natural thing that you find in the world like a human being or a human person could be. Okay. I want to give you a little vista into what person looks like in the law. And I want to just give you a legal definition of person that is taken from something called a law dictionary by John Bouvier. I suppose he's a fellow countryman of mine, and in 1856 he gave this definition of person. I use a definition from 1856 because it still contains the Roman and classical inheritance of person, which always includes slaves and things like that, and great divisions and hierarchy and things of that sort, but also starts to get at some of what we would call a modern person with rights and things of that sort, or human rights has. So here we are. Person. This word applies to men, women, and children who are called natural persons. In law, man and person are not exactly synonymous. A person is a man considered according to the rank he holds in society, with all the rights to which the place he holds entitles him, and the duties which it imposes. It is also used to denote a corporation, which is an artificial person. But when the word person is spoken of in legislative acts, natural persons will be intended, unless something appear in the context to show that it applies to artificial persons. Natural persons are divided into males or men, and females or women. Men are capable of all kinds of engagements and functions, unless by reasons of applying to particular individuals. Women cannot be appointed to any public office, nor perform any civil functions, except those which the law especially declares them capable of exercising. They are also sometimes divided into free persons and slaves. Free men are those who have preserved their natural liberty, that is to say, who have the right of doing what is not forbidden by the law. A slave is one who is in the power of a master to whom he belongs. Slaves are sometimes ranked, not with persons, but things. But sometimes they are considered as persons. For example, a Negro is in contemplation of law a person so as to be capable of committing a riot in conjunction with white men. Persons are also divided into citizens and aliens when viewed with regard to their political rights. When they are considered in relation to their civil rights, they are living or civilly dead. known as civil death, and outlaws and infamous persons are sometimes counted as civilly dead. Persons are divided into legitimates and bastards when examined as to their rights of birth. When viewed in their domestic relations, they are divided into parents and children, husbands and wives, guardians and wards, and masters and servants' son, as is understood in the law. And there's a period at some point after there's a number of references to legal texts which are authoritative or considered to be so. Okay. You probably squirmed a little bit when you heard certain things in this legal definition of person, but then you recognize some elements that we would still lump with it. You may have recalled the last lecture about the dangers of person from Professor Cottingham, and you may have enjoyed some of the historical inheritance of bygone ages that are not as romantic as we wish they were. But some relevant points that natural and artificial persons, and artificial is always the term artifice, not the term false. So artificial person is artifice, constructed, not false. The second is person in law is usually opposed to things. And persons can own but not generally be owned. Remember, slavery, there's kind of this middle ground. Are slaves persons? And if they are, how can they be owned? It's a bit of a legal problem. They can be controlled by another person, as when a son is under paternal power. They can be sued in court, and they are centers of legal responsibility. Things can be owned but not owned. Might seem obvious, but relevant here. So keep this modern legal definition of person in law in mind as I race quickly through a history of the term. The Romans and Boethius will have some of the definition, but not all of it, and they'll have different sums of it. Okay, I'm going to begin with the theater, person as a mask. And it's important that we always remember the theater when we think of the word person, because something of the theater is never lost in the way we speak of the word person. You know that person, persona in Latin, or prosopon in Greek, originally was a fixed mask through which a voice was projected on the stage. And you could be Apollo or Orestes or Athena, but you were a personage. And the you, it was less important than the person. So the actor behind the mask, much less important than the mask itself, who would actually be the player you saw on the stage. So there was a distinction between the persona, the player, and then the instance, which was the voice of the player that becomes the persona's voice in this specific act of Athena or Apollo or Orestes. Yeah? It's not a moral or metaphysical category that we're looking at when we look at person on the stage, or when we abstract it from the stage, and in law it becomes a mask. It is a public status or place in relation to others, and it has a certain history. So when, Zeus isn't normally put in the mask, but when Apollo is put in the mask, the people watching already know something of who Apollo is. And that's inherited by the tragedy. And then it is, in a sense, the instance of this personhood, with the player speaking out the play that the tragedian wrote, becomes a modification on a theme of the personage of Apollo. But the important part for us is that mask can be taken off and worn by anyone. Anyone who can speak out the lines can wear the mask. And person is not here in any way concerned with the inner being or the dignity or the moral status or any other part of the person actually on the stage. So the persona matters, not the person or the player. Okay. So notice that something, I suggested this already, of the theatrical usage has never really fully left the word person. When we say, he's not the person I thought he was, we get a little bit of this. But the phrase, unmasking the person, which has this nice poetic ambiguity, because you don't quite know which is the person and which is the mask. So retains some of this inheritance from the theater. The Roman law of persons picks this up, person as a legal mask. And civil law, which still operates on the continent, in some ways is a purer case for those with philosophical interest in persons, since the law of persons is separated out from other things, as it's not so clearly separated in other legal systems. Just for your information, Roman law was originally a pragmatic case law system, a kind of a common law, where you would go to the praetor and he would say the cases he would see that year, and if it fit into one of those cases, he would give you a solution to your problem, rather than having statutes that were written and that you could appeal to before a judge. It eventually evolved into something that could be recognizable as specific laws of something like persons and things, and private law and public law and international law and that. But in fact, that categorization comes so late in the history of Roman law that the Romans didn't have it. It comes in the Salamancan school and in basically the late scholastics putting this together and coming up with a law of contract and persons and things like that. So the first thing to recognize is that when you speak of a Roman law of persons, you're not speaking of something that can be easily divided out and just say, there it is, the law of persons. But you are dealing with certain rulings or certain facts in Gaius or in Justinian, in the Digest, that we understand to be part of the law of persons, and that eventually become part of the law of persons in the codifications of the 19th century on the continent. And some of them even made it into common law when the contract law of the French was brought into the common law, because Blackstone didn't have a lot to say about contracts, and the French did, so it was just imported. So some of it even made it to these islands. Okay. Person has a legal category and a legal mass. It's a public face that owns, disposes of property, can be sued, can be killed procedurally through civil death, and it was defined within the law. It's something that emerges within the system. You don't have persons outside of law, although you do have human beings and man and woman and all of these other things. At least not originally. You don't have persons outside of law. There's a great overlap with citizen, but they're not synonymous, person and citizen. There's great overlap with man, but again, not synonymous. And person was known consciously to be artificial in both its human and corporate instances in the law. So we might say today corporations aren't really persons because it's just the law. The Romans might have said, you aren't really a person, it's just the law. In Roman law, a person had status, but not moral status. They had rights, but not human rights. Rights, like duties, were historically acquired. So a Roman might understand a right as a deed, or the equivalent of a deed that gives him the freedom to use a piece of land, to dispose of it as he sees fit within law. So the very term right normally denotes to us something that might be derived from my nature as person, if we're dealing with human rights, or if we read the preamble of the Universal Declaration of Human Rights. This is a bit strange to the Romans because they're much more historically minded about these things. You acquire rights and duties over time, but the curious part is you don't acquire them in your natural person. Your legal person acquires them. And especially in early Roman law, your full legal person could be inherited. So your father dies, you inherit his legal person, you become him publicly, with all the rights and duties and obligations that apply to that. So you see very clearly it's like taking a mask off the father and putting it on the son. Now, as I said, there's not a pure law of persons in Roman law, so there are cases and instances which seem to oppose this, and eventually you did develop it so that, for example, you could inherit your father's person insofar as inheritance was concerned, but certain debts would only be attributable to that person wearing the mask, that individual wearing the mask during that time, that lifetime. So there was some ability to separate the public mask from the person who inherits it, once again, from the person who had it on last. So, and what that does then is says it's important to know when this duty was acquired and who was wearing the mask when it was acquired to know whether it passes on to the next person who wears the mask. They didn't speak about it in terms of mask, obviously. They didn't speak about it in these ways. They had a case that needed a solution, and then in the solution they had to reconcile it with the other solutions that had been given to problems in the past. Okay. For us, and I've kind of implied this a little bit. For us, okay. Now, or for us, one cannot kill the human person without killing the human being. For Roman law systems, you could do this, as I said, with civil death, and vice versa. And this was also implied in the modern definition I gave of person, but let me just say it. Slaves, women, infants, Jews, Christians, foreigners, and the list goes on, were at various times not able to wear this legal mask. As you know, there was eventually full emancipation and full Roman citizenship, and then citizenship would then correspond in some way with person. Christianity became tolerated. Judaism was less tolerated. There was a lot of changes, but at various times, all of these different categories weren't able to be persons. Okay. So, as I said, person is not yet a metaphysical thing in the world, a substantive thing, and it's not yet a moral category. But we know that it does become this, both of those. So person as a metaphysical reality. I'm going to argue briefly that moral status comes through the metaphysics in the word person, so through ontology. And it happens very clearly and quite lastingly when Boethius gives a definition of person in order to solve a theological problem. He grabs a word that is already being used in Greek theology, brings it into Latin theology, and he could read both. He grabs a word that has many usages, and he gives it a very Aristotelian turn, or twist, or definition. And he uses eventually the word dignity, or near approximations, to talk about what this person eventually is. He's trying to solve a problem. How can Jesus be one person, or one thing, with two natures? And person is the way he provides a solution. I won't go into that, but if you want to read Boethius, you need to read his tract against Eutyches and Nestorius, where he tries to solve this problem. Okay. Boethius says it's an individual substance of a rational nature. Individual, as a philosophical term, is something that a tree could be. It's indivisible, incommunicable, and uncombinable. So you can't cut a tree in half and get two trees. You can't add two trees together and get a bigger tree. And you can't share the tree's existence in something else in any way that we can conceptualize. And that's what is meant here, at least part of what is meant by individual. The substance here, the best word we can put in for substance for our purposes is thing, right? And of course, as an Aristotelian, it can be the basis for accidents. It's first substance, very clearly, that he's speaking about. The thing there that we can point to and touch, taste, feel, or think on, that can hold accidents, can hold color, or maybe shape of a certain kind that might not be part of its substance. Okay. Rational, this is not necessarily discursive reasoning or the process of logic, but the potential for all things that we count as reasoning or logoi. And you can look at it kind of as a metaphysical category. It's like saying, defining an eye, but not talking about seeing, not talking about anything the eye does. Of course, an eye still has the nature it does, even if it's diseased, even if it never sees a thing, it still has the nature of a thing that's able to see. The individual substance of a rational nature, even if it never reasons, has the capacity in itself to reason. And that relates to nature. Okay, nature is a very tricky word in Greek, in English, in German, in any language you want to mention, because it can mean so many things. It can mean all things. It can mean something that's non-volitional, something that's natural disaster, for example. But here it means the specific difference that gives rise to what the thing is. So the individual substance, the individuated first substance of a rational nature involves a nature. The thing that makes it different from other natures is that it is rational. Okay. what you should note about Boethius' person is it seems to have no will, or even maybe soul, or even body, or even, and you can go down the list of things. This is a very broad definition that you might know when you see it, but most of the things we call persons have a lot of other stuff that we seem to think are quite important for being a person, including corporeal existence and volition. All right. Person as a moral entity. I suggested, Boethius did say that hypostasis, the word he uses for a person eventually, is in fact a very dignified thing. It has a dignity, and the word is used by the Greeks, he says, because it has this dignity. He suggests this. So dignity is already now being mentioned with person in a way that it wasn't with the Romans, and that the theatre did have a bit of this. And I'll suggest this. I'll suggest why dignity might come back quite easily to the term person. You don't have personages or masks in the theatre of an unimportant or undignified human or god or whatever. The theatre makes masks of dignified, so worthy, or those with status, and plays them on the stage. Roman law didn't seem to have that necessary association with persons, except that they were more dignified than things, right? They had a separate status and a separate worth from things. They couldn't be owned, generally. It's explicitly mentioned by Boethius that dignity is probably why the Greeks use hypostasis to talk about person. And that gets carried over into the Latin debate, which Thomas Aquinas picks up after it goes through some other permutations, which I think you'll hear some about in a nice paper, one of the parallel papers later, about perhaps the pre-Thomistic emergence of person. Yeah. And so what you have here is person moves from a metaphysical entity to something that is also a moral entity. And I think dignitas is one of the things that moves it into this category of a moral entity. A moral entity in the sense that other creatures in the world or other things that share this dignity can't just do with it what they please. It has a certain status that cannot be violated in some way. Okay, Roman law had this. If you had acquired rights as a person, they couldn't be violated without due course of law. But it was associated with the history and with something that was acquired through time, not with something in the nature of the thing. And it seems that once Boethius gives us a metaphysical or ontological definition of person that includes dignity in some way, you then start to pack moral worth or moral reality into the definition of person. And Thomas Aquinas eventually says in his discussion of person that person implies dignity. He just comes out and says it. He says a lot else, quite interesting. And he shows us that person implies dignity by saying, oh yes, and God is three of these things, these persons, and the most perfect of these three. He kind of imports a Neoplatonic form of person almost into the definition, where God is the most personal, the personness itself. Human beings are also this, but God is really this, in question 29 of the first part of the Summa. So this would lead people who've thought about Thomas's definition of person, especially in the modern context, to say something like Karl Wojtyła said when he said, whatever is a true perfection in the created world must be found in the highest degree in God, and so the person too, which signifies the highest perfection in the world of creatures, must be realized in an incomparably more perfect degree in God. And you structurally, if you're familiar with the Republic or with some of Plato's purer formal dialogues or form-based dialogues, can understand this gradation of participation, so that the thing itself is the true, and we are the thing insofar as we participate in the thing itself. So goodness is reflected in this world, or participated in this world, and the more you participate in it, the more you are good. Denying personhood after this fact, after Thomas and Boethius have made it a metaphysical category and a moral category or moral entity, seems to me to constitute now a moral evil, rather than just merely a legal injustice, or ironically what it was for the Romans, it was part of legal justice itself to deny personhood to all kinds of human beings and other things that might count as metaphysical or moral persons to us. Now, the person, when it moves into this dignified status and when it's thought to be an individual substance of a rational nature, also becomes an individual seat of responsible agency. Now, this has there's separate arguments behind this, but part of it seems to be that person, as I suggested before, has something of this recognition of dignity in it, so other persons would be the types of creatures that could recognize this dignity and respond accordingly, and obligations emerge from that. So now, if we were to say, it makes sense for us to say, you can't do that, I'm a person, if someone assaults us on the street, and this also becomes much more meaningful than saying, you can't do that, I'm a human being, or you can't do that, I'm a citizen, or you can't do that, I'm a member of a certain family, or you can't do that. So it takes on a very important role for us in not only self-understanding, but in moral self-understanding. So much of the question of obligations and the question of moral responsibility has to do with choices. And I think what's implicit in the moralizing of person is that you're dealing with something that can do otherwise and that does do otherwise than recognize the dignity of another person. And there's an implicit will present here that's packed into the definition, so that person would eventually have to imply a will. A person that's metaphysical and a moral metaphysical and moral reality would have to be the kind of thing that has a will. You couldn't find one of these without a will. I'll say something quickly and then go to the last part and wrap up. Recognition of personhood for us, now legally for us, after inheriting some of this tradition, is actually the foundation of certain positive rights, that is, obligation on others, and of certain negative rights, that is, the obligation to refrain from certain acts of us or in others. And if we're going to get rid of the word person, as I think there'll be conversation about after John Cottingham's very interesting paper, we have to ask, okay, and then what happens to these other legal and social and moral realities which have built a lot of the worth or the dignity and the rights eventually into this term. Peter Singer might abuse the term, but is that reason enough for us to throw it out? Maybe that's a way to phrase it. All right. One other interesting aspect of what I'm arguing is that what you might call the homo turn. And it's not the homo you're thinking of. It's that person becomes more and more synonymous with man. And I suggested Hobbes before, and Hobbes is curious to me in this respect because in some ways he participates in the scholastic inheritance of conversations about the polis and about peace, especially. You know, Leviathan is nothing if not a treatise on how we get peace. And he even appropriates certain inherited scholastic concepts and ways of reasoning, all the while saying he wants to throw out Greek learning, throw out Aristotle, and so forth and so forth and so forth. And notably, he doesn't start reasoning from person, he starts reasoning from man. Man, the senses, the natural condition, and so forth and so forth and so forth. He does eventually speak about persons. And ironically, he gives us the great corporate person of modern politics, which is the Leviathan. Has a longer history in German and language and politics than in English language, but the corporate person as the state, if you pick up Hegel, you'll find this recurring again and again and again, is extremely important. Hobbes gives us a viable model of how this works. So ironically, he starts with man, and he doesn't have a tremendous amount to say about man as person, right? His man in his natural condition is a non-personal human being. Or you might even say unpersonal. It doesn't really concern persons. It's about man, the facts of reality, and about how, through maybe an exercise of proto-game theory, one can achieve political peace so he can not be afraid and fulfill as many of his desires as possible. But it's not about persons. It's about maybe an individual, and it's about and it's about man. This turn is followed or is helped along by the natural sciences study of man, and of course by humanism's turn toward the study of man. And this turn to the study of man does not necessarily preclude studying man as a person, but in practice sometimes there's deliberate omission of person where person once played a vital role. And one of the most famous is the revolutionary document of the French Revolution, which is the Declaration of the Rights of Man and of the Citizen. Now, we don't know if the authors said, let's get rid of person. But the fact that they did help to continue to set a tone that what we're dealing with is a political constructed reality and nature. And persons don't belong in law, and persons aren't going to be how we speak about obligations to one another. Now, there was a restoration and a codification in the early 19th century in most European legal systems that restored person to prominence. The point I'm making is there's this move that is pushing on person to continue to move it toward man as, or the human being, as what really matters, and person as a way we speak about it. Okay. I understand this is sketchy and I'm painting with a big brush and maybe it hasn't all connected and you can tell me that in the question time. And I have no time here to fully connect it. But let me return quickly to the question, why are corporate persons so hard for us to understand? I've suggested that person is more and more an idealized human being, and I suggested at the beginning there's three things that become important. That it has become nearly to mean a human being in its primary signification, that it seems to mean individual, especially corporeal individual, and that it implies volitional activity in such an individual. That is, persons are beings who desire, choose, have wills that are in some way free. When we think of a corporation as a person nowadays, what we kind of do is we say, well, who's the person who ultimately is deciding? Right? We kind of tend to say, well, a corporation can't really be a person. There's somebody, if we dig down enough, we're going to find a seat of moral responsibility that has a will and a body, and that's really what we're talking about when we talk about the person within the corporation. Corporate executives, in the sense, wear the mask of the corporation, the person of the corporation. And we, again, are looking for the decision points, the corporeal point of decision to find the person. This trend, I gave you four things to think about at the beginning, right? I said corporations, great apes, the unborn, and what's the last one? Bart Simpson, right? If I were to suggest, as we're moving forward, which of these will be able to retain some sort of legal and moral personhood, and which won't, I would suggest that great apes will increasingly be granted legal and moral personhood in Western Europe and probably North America because they have bodies, they're individual, and they seem to have wills of some kind. They can act, so the functional part of the definition is present. Bart Simpson is an interesting case. It seems like he's become a person to avoid real persons from abusing real children. However, he does have a body, right? At least we can imagine him having a body. And so in some ways it's easier for us to argue that this guy should be considered a person, as was argued in Australia, than corporations. I don't think it bodes very well for the unborn and the very young of human beings, because the unborn can't really be seen and clearly don't have volition, and whereas little babies do have individual substances, we're not as much concerned with the rational nature. We seem to be concerned with the volitional nature. And for quite a long time, it's hard to really figure out what they want. They have a lot of trouble expressing this to us. And for some, like Peter Singer and others, this creates a real problem. I'd suggest it's not only Peter Singer's problem, but it might be a problem of the way this very complicated term has developed and how that development has interacted in an imperfect way with different legal systems. I hope I hit some of what I was hoping to, and if not with precision, then maybe with accuracy, or the other way around. And I welcome your questions on this.